Right now, I have Crystal Goodby up. So with the Community United for Safety and Protection, thank you very much for coming here. And I was going to go to Kenai, and I lost the police up there. So my apologies. Then I'll go to Butch Moore right after this. So Butch, you're going to be up after this. So please give us your testimony. Thank you.
I'm with Community United for Safety and Protection, and I'm here to ask you to remove Section 20 of Senate Bill 54. I'm a former sex worker. I worked for 3 years. I didn't do it because I liked the work. I did it because I was homeless and I was a drug addict. I've been sober now for 13 months. When I worked, us women knew that we couldn't call the police if anything went wrong. We had to stick together and look out for each other. We would talk about clients. And tried to share good clients. We shared hotel rooms, and we gave each other rides to calls and waited outside to make sure our friends were safe. Sometimes we hired people to drive us and wait outside. When you turn our safety measures into felonies, it makes us less safe. People don't want to look out for each other. It means people don't want to look out for each other if it means catching a felony, and it puts our lives in danger. If Jackie Goodwin had someone waiting outside for her, she might be alive today. I've given a similar testimony to the Criminal Justice Commission this summer, and it surprises me to see this bill is attacking our safety now. Please remove Section 20. And I also would like to say, since Senate Bill 91 has came through, I really encourage you guys to listen to what they have to say. I actually have a Class B felony on my record, and what I have seen is when I was in jail, we would have repeat offenders. Girls that would come in every other week. And since Senate Bill 91 has been through, probably about 75% of those women are at home now. They have jobs, they have kids, they're married. So it's working. It just, it takes time for things. So thank you.
Crystal, thank you very much for your testimony. And I think that we tried to address your question in there, but we'll certainly be open to further discussion. And I know that Tara is going to be up also to testify. Thank you very much.
Thank you.
So please put yourself on the record, Tara, and give us your testimony.
Hi, I'm Tara Burns, and I'm with the Community United for Safety and Protection. And I'm sorry, I have a little bit of a cold, and it still makes me nervous getting up here in front of you guys.
If you keep it to yourself, we're happy.
I'm trying. I'm here to ask you to remove Section 20 of this bill. I first became interested in policy around sex trafficking when I was 16, and a district attorney in Fairbanks decided not to charge my father with trafficking me because they thought that juries at that time did not like teenage prostitutes. Since that time, I spent about 2 decades working in the sex industry before I retired. I completed my graduate research at UAF on the lived experiences and policy recommendations of people in Alaska's sex trade as part of my master's degree. That research now has been replicated at Brown University, and I travel all over the world talking to people about sex work and sex trafficking policy and research. Most recently, I was in England, where I spoke at Cambridge Union, and I advised researchers with Amnesty International. Section 20 of this bill proposes to remove subsections of Alaska Statute 11.66.130 and 135, which prevent prosecutors from charging prostitutes with sex trafficking if they have not induced anybody into prostitution or are not in a location with a sex trafficking victim. You've heard a lot of things about what sex trafficking is, but I think we should be very clear that 11.66.130 and 135 only apply to having a place of prostitution, which can include a prostitute's home or hotel room, and to aiding or facilitating prostitution, which is so broad that a woman in Fairbanks was charged with sex trafficking herself for aiding and facilitating her own prostitution. You heard earlier that sex trafficking involves force and coercion, but we don't even have coercion in our Alaska statute. We should. We should have coercion. We should have threats. We should have, threats against victims' families, especially. But we don't have that. Force is, defined in 66.110. and there's no exception in 110 or 120 for people who are engaged in prostitution. The legislative and administrative intent was clear in creating the sex trafficking statute in 2012 that these statutes were to be used against people who exploited and harmed sex workers, not against sex workers themselves. But every person the Department of Law charged under these statutes in the first 2 years, 2012 and 2013, was an alleged prostitute charged with prostitution of herself in the very same case that she was charged with trafficking herself. Legislative intent was clear last year in creating the subsections that Section 20 would remove, that sex workers who have not induced anyone into prostitution should not be charged with sex trafficking when their conduct amounts to prostitution. Despite this clear intent, you heard Wednesday from Mr. Skidmore that this was an accidental loophole. This is not an accidental loophole. The Department of Law wrote in a June 17th letter that no one ever had or could be charged with trafficking themselves under these statutes, even though they clearly were aware that they had filed these charges and discussed it during the last legislative session. In their recommendations to the Criminal Justice Commission, the Department of Law wrote that these sections would prevent them from prosecuting independent sex workers working in the same location as a sex trafficking enterprise. This is untrue on 2 levels. First, a prostitution enterprise is defined in 11.66.120 and not affected by the subsections that this bill proposes removing. And second, the subsections clearly say that if a worker is in a location with a person who has been trafficked, they can still be charged under 130 and 135. More importantly, if a sex worker found herself in a location with a victim of genuine trafficking, the sex worker should be encouraged to report this crime rather than being hunted down as a sex trafficker herself. Sex workers and clients of sex workers are usually the first responders in sex trafficking situations, and your responsibility to public safety demands that these people not face felonies for reporting these situations to law enforcement. 11.66.130 and 135 are so broad that they even define many sex trafficking victims as sex traffickers. I can tell you of at least one case where the subsections this bill proposes removing worked as intended, and a victim of violent sex trafficking was able to make a report after she was assured that she and other victims could not be charged with trafficking for driving each other to calls or taking pictures of each other for ads. But you have not heard of any cases where a perpetrator was harming someone and could not be charged with it because of these subsections. Removing these subsections is not based on any evaluations of how they have impacted public safety or cases that weren't charged or were reported because of it. This is a strong departure from the evidence-based nature of SB 91 that should not be permitted to move forward. Although the trafficking statute was not in existence when I was a juvenile trafficking victim here in Alaska, back then it was part of the SAM laws. If it had been, these subsections would have allowed sex workers who were my coworkers to report my abuse so that I would not have continued being trafficked for 3 years. Removing these sections puts sex workers and sex trafficking victims at risk. And when you create laws that put us at risk, they get played out on, we see them used against sex workers and sex trafficking victims who should not be the experiments for how these laws are going to play out. The proposed definition in Section 5 would not have allowed the woman who worked with me when I was a victim to report without being charged, even if the definition were not so unclear. However, as written, the definition causes undue confusion and will prevent the reporting of actual violent crime. I want to also encourage you to listen to the addicts and felons who have testified today. There's a lot of things to talk about, but there is, some overlap between our communities. When I was listening to Kara's testimony, it reminded me of a sex trafficking victim I knew who caught similar evading police officers, a Class C felony, and was charged as an adult. When she was a 16-year-old sex trafficking victim, and her pimp had instructed her to speed up and evade the police. Please remove Section 20 from this bill, and thank you so much for the opportunity to speak and be heard. I'm happy to answer any questions, and I do have a copy of the current statute here if anyone needs one.
Thank you. And Ms. Burns, the commission had asked us to come up with a definition, and I think that's right to challenge it, so we'll try to pay attention to that. It's also true that we really ramped up the penalty for sex trafficking because we find it so egregious. But in that ramping it up, what you're trying to tell us, and I'm going to paraphrase it, is that the different penalty, which is a lower penalty for prostitution, if one is making their own self available for sex for money, is probably going to be in. That's a lower penalty, but if they are going to tell on somebody who's doing sex trafficking, that they end up being part of that sex trafficking. So that we're trying to make that correlation. How do we, we find in our law prostitution unacceptable, but trafficking is much more unacceptable, right? So we're trying to balance between making sure that the one can be properly dealt with by law and the other one can be properly dealt with by law. And you're saying we're making it unsafe for those who are trapped in it. So in this law that we're dealing with, and it's not something, I mean, it was something that kind of was brought to us as we were going through Senate Bill 91. If you have places where that language cannot work, please make sure that all of us get a very concise piece of information to help us with that. And I would make sure that all the committee members get it.
You have all received a letter with very concise information about that.
Well, I need some language that I think is a little more clear than that. So maybe we can get back with you on that.
Sure.
I do have a question for you from Senator Costello.
Thank you. Thank you very much for coming here today to testify. I was just curious if you could provide your testimony today in writing.
Yes, I can.
Okay, thank you very much.
And thank you for coming before the committee. And this is a work in progress. So